and service has not been completed, my lord. That's why I'm praying, my lord. As prayed list after the holidays. Second week after the holiday. Different one. Another this is, I think, it's better. In all the cases with doctors. Lord, I am applying for the respondent writ petition. Appellants are. What is the issue? Tomorrow premature retirement. Premature. Punishment, by way of punishment. By punishment, after General review. CCS pension rule. General review. CCS pension rule is a provision to retire day, to chop up the day rule. The petition's case is for the last 15 years, he has been graded as either very good or outstanding. Either very good or outstanding. 15 last 15 years. Last 10 years. ACR. 10 years. Which service? CISF. And he has got CCS will apply to CISF. This is under CCS pension rules. I know. Civil service pension rule will apply to the CISF. I know. Under which provision? There must be some provision. CCS pension rule. CCS rules, because pension is getting from CCS pension rule. CCS pension rule, CSF person will get pension only for Rule 71 says also. CSF Rule 71. Rule 71. Right. So same as applicable to central government. So there has to be a provision. Otherwise, how a civil service rule will apply to a armed service?
I'm led by Mr. Trivedi. He's stuck in a court number 12.
You start, madam. You tell us what the case is about.
Lordship, I'm not a panel junior. I'm a chamber
junior. Just let us see. Where is the order? You can proceed. You are ready to proceed. And what has been done by the Honorable Single Judge, that order has been set aside? Set aside, has been direct to be reinstated. Detailed order, my look, have a look at the order. And memorandum of appeal, my lord. It starts from which? The only issue is whether this, what do they call it? Screening of dead wood. My lord. Whether he is dead or not. ACS will say, my lord, whether he is dead or not. But the scope of review is very limited. It is, if it is based on no material or if it is arbitrary, then only it can be interfered. Because it's not penal. No, not. It cannot be said as punishment. It cannot be said to be penal. So on what ground the Honorable Single Judge interfered? Well, guy says, my lord, he has got 23 cash rewards. He can, in his service. 23 rewards. Cash reward for his excellence. In service. For excellence in service. Last 10 years, ACR has been said, he is very good man, he is very illustrious, he is hardworking. All good qualities are reflecting in the last 10 years. There's London Singhji was pleased to call for the record. Examine the records and there's the order. The records were also requisitioned. Not by the London Singhji.
Weeding out the dead wood from the service. Where is the order of your premature retirement? Which page?
Sir, my lord, that will be at can two, my lord. Can two. Can two, page 28. So the 2 p.m. चाहिए ना? এখন টিপিক্যাল 2 p.m. चाहिए ना? বা কালকে বিকেলে just
So what is, there are certain portions of the order which we cannot read. What does it say?
whereas the in excess of powers conferred by clause 56 G of fundamental rule
56
J
J. Yes.
and civil service pension rule 1972, the deputy inspector general being the appointing authority hereby retires number with the immediate pay. He has having already attained the age of 50 years on 25. Mine also are copy.
And shall be paid a sum.
Copy given to me also regiment. I will have the paid equivalent amount to the allowance plus period of notice. That's all.
For how many months?
No,
An adjournment is sought. Twenty-third. It will be 23 instead of 22. Madam, it will be 23 instead of 22. 23-6.
Number 3.
My lord, in this matter, I am on behalf of the respondent, my lord.
Madam, Mr. Rajesh Kumar Shaw is appearing for the petitioner, my lord. My lord, on his behalf, my lord, I am praying for an adjournment on this matter.
After
On his
holiday.
behalf, I am praying for an adjournment, my lord.
What
Due to
happened?
his personal inconvenience, my lord, he has could not come to court.
My lord, in the last order, you had directed to file the paperwork. It is a long drawn case, my lord.
What happened? Paper book, why you are not filing?
My lord, due to his some personal inconvenience, my lord, he has not come to court today, my lord.
No, that's all right. But what steps you have taken for filing the paper book?
My lord, what he has
File it in a day or two. We'll adjourn it to after the holidays.
Yeah, okay. There are my lord, certain documents, my lord, given handed over to the my lord, learned advocate on record, my lord. He is newly engaged, my lord, on behalf of the petitioner, my lord, for preparation of the my lord, paper book. Project, my lord, by after, if your lordship could have fixed the matter after vacation, my lord, that could be filed, my lord.
Granted you time for paper book on 6th. Granted you time for paper book on 6th May.
Yes, my lord.
That's true.
You are knowing that it will come on 19th. So we do not appreciate such casual attitude. No, you file it this side of the holidays.
Four.
I appeal for the respondent numbers to
Lord, the advocate on record, Advocate Anona Yogi, my lord, she went through a surgery just yesterday, my lord.
Surgery.
Yes, my lord.
You are for
For the respondent corporation, 2 and 3.
which corporation? Which corporation?
Well, the West Bengal Livestock Development Corporation. The petitioner was an employee of the corporation,
You already paid everything. What remains?
and the post to which he is claiming, but that has not been sanctioned by the government.
So there is any provision in you are governed by the WBSR rules.
But no, they have their own rules as per their memorandum of association.
Is it on record?
Yes, it is on record.
So what is see, normally if somebody is asked to do the work of a post and from the day he assumes the office, he is entitled to the pay and allowances attached to the post. So this is so what is the
What happened, was that he was upgraded to a post. He was an assistant accounts officer. Subsequently, the board of directors upgraded him to a post of accounts officer. Now there was no sanctioned post of the accounts officer. After upgrading him, they sent a representation to the government. Now, subsequently, the revision of pay rules came in. But there also the post was not mentioned. Various representations were made. But ultimately, the government said that no, there is no sanctioned post, and therefore he is entitled to whatever he is entitled to as an assistant accounts officer. So that was paid. And ultimately, because of this, he retired in the meantime. Because his pay scale was not fixed, he was in limbo. And ultimately, the Honorable Single Judge held that whatever delayed payment, he should get interest. That interest has been paid. That was directed at
interest with reference to his
earlier post.
Emoluments of assistant accountant.
Assistant accounts. That he has been paid, and he has been paid the entire interest part also. But in the absence of a
so for how long he was on the upgraded post?
Upgraded post, about 7-8 years.
7-8 years.
But the difficulty is that he was doing the same job, and there is nobody in the accounts above him.
That we have understood what you are saying. What we are trying to understand is, if there is a stagnation, he is not entitled to any benefits under the.
But to that career advancement he will get. But
so have you given that to him?
But career advancement has been given. In his post, whenever there is opportunity, he has gone to the next higher scale and so on. But this scale of accounts officer, he is claiming in respect of an engineer of the government departments. That has never been given because that has not been included in the ROPA rules. And the government was very specific on that.
Under the ROPA rules, there is no provision for a need-based post.
For that post, it has not been approved for this.
No, we are not talking about approval of that post. There must be some provision saying that there are certain persons appointed to posts which are need-based posts, even though they are not against a sanctioned post. So is there any such provision in
we have not come across, that was also not his argument in the case. And the difficulty is that this is a wholly owned government corporation. So unless the government approves, we really have no role.
No, that is a difficulty for you. Not for us.
No.
Therefore, we are asking
certainly not. So far
therefore, we are asking you whether
yes.
If there is a provision, because see, if his employer has thought that he is in a post which has no prospect and given him a higher scale in recognition of his work or number of years of work, and he is performing any duties, then
the difficulty was that for a
there is a concept of need-based post.
I bow down to your lordship. But when we argue the appeal, your lordship will find the corporation itself was defunct for about 8-9 years because it did not have any business. So at that point of time, there were about 15-16 employees. The government paid their salaries, but there was no activity of the corporation itself. Then slowly it again merged with another corporation and then developed its business.
A series of adjournment only, one after the other, for a long time.
My lord, kindly takes it after vacation, my lord.
No, that's all right, but this is not, we don't appreciate this. From 21/7/25, there are so many orders of various benches. 3-4 orders before coming before this bench, then another 4-5 orders before this bench. Every day it is adjourned. At least there are 10-11 adjournments. Oh, you said she is undergoing surgery. Today we are informed that
File.
That matter, my lord, the learned single judge, though held that I was deserved to be appointed, but somebody has been appointed.
after holidays, none appears for the state.
Number 6.
This is my matter, my lord. Will kindly remember, my lord. Yeah, my lord. The award was given, my lord, outside the reference, my lord. Yeah, my
There
lord.
is an interim order
My lord.
in your favor.
Good order, my lord. Was that, my lord? I have to give back wages that we have already given, my lord. Because, my lord, he was terminated from the service, and my lord, we could not show document, my lord, that we have served him second.
No, please. Can you say that again?
But the case is that, my lord, the employee was unauthorizedly absent, my lord. We started a disciplinary proceeding in that.
He was a workman or he was a
My lord,
Yes.
employee.
workman? No, employee means of in the officer cadre or workman? Workman.
Now, my lord, he was unauthorizedly absent, my lord. So, my lord, we initiated disciplinary proceeding, and thereafter he has challenged the disciplinary proceeding. In that disciplinary proceeding, my lord, we could not show, my lord, that we have served him a show cause notice, my lord. So, my lord,
Second show cause.
yes, second show cause notice, my lord. So, say the authority, the CCGIT
The
has
disciplinary authority accepted the inquiry report
not accepted the inquiry report, but
without giving a show cause.
well, that's so,
So
my lord.
not a case of difference with the opinion.
Now, my lord, so for that reason, my lord, his termination was declared illegal, and my lord, we were directed to give him back wages. And also, my lord, during this pendency, my lord, he died, my lord. The employee died, my lord. My lord, so my lord,
So now there can be no proceeding against him.
now, my lord, his wife was substituted. Now, here, my lord, the mistake done by the authority, my lord, was that, my lord, he was given back wages, my lord, till his death. That we have also given. But thereafter, the authority has said that he has to be given MMCC or minimum MMCC till to taking that authority, that workman was alive till his retirement. But taking that workman, how long he would have for work, till that we have to give him MMCC.
This is the direction of the single judge.
But the CGIT, well,
Huh?
the Central Government Industrial Tribunal, CGIT. Well.
Oh,
Now challenging that one, we came
CGIT.
challenging that we came before this court, my lord. The court directed us to deposit that entire back wages. We deposited with the register, and thereafter, my lord, that amount was released. But we have also released.
Released in her favor.
Yes, it's in your favor.
Now it's only issue whether MMCC is to be paid from.
Yes, ma'am. Firstly, I will say, my lord, it is not the reference, my lord. That reference, it was not the cause of action or subject matter of before the CGIT, my lord, to look after that, my lord, when the authority dies, my lord, for thereafter what he will get. Because the challenge was, my lord, his service, my lord. And he also asked for reinstatement. The authority said that he should not be reinstated because he has
The
died.
reference was limited to the departmental action.
Department taxes. But my lord, the authority, my lord, if I will just show to you, lordship, my lord, has given back wages and till as if we are responsible for his death, my lord. But he has died natural death, my lord. But my lord, we have been penalized, my lord, saying that we have to give him the MMCC benefit till, my lord, he was alive. The other, was alive.
Yes, madam.
Your Lordship will kindly peruse the order dated 14 January 2026 passed by this bench, my lord. My lord, where your Lordship hold that the learned advocate for the writ petitioner appellant that the industrial tribunal imputed order in the writ court found that the order of punishment unsustainable and required the employer appellant to pay back wages and from the date of the demise of her husband till the date of his notional superannuation, to grant monetary compensations to the respondent. The National Coal Wage Agreement dated 28 September 2020, however, provide for payment of MMCC and other benefit. The learned advocate for the respondent I submitted, but it is prima facie appears that the benefit under MMCC may be more beneficial. This court hold, and there, however, she will express her stand of the respondent before this court only after obtaining the instruction. I have got the instruction as they are agreed to get the MMCC benefit which the court is going to provide, my lord.
Then nothing remains.
Yes, my lord.
They-
My lord, I'm also
that
praying
part, my lord, has to go.
for service to her son, my lord. My lord,
Please don't ask your client to come. We don't appreciate that. You are here.
yes, my lord.
That does not make any difference. We know that she must be in a very bad situation. We can understand. We are asked at the outset whether we are dealing with a workman or somebody working in an executive cadre. He said, no, it is a workman. We know what is going on. So therefore, we have also gone through the order sheet. In a way, the court advised you to take instructions so that you can get MMCC. If you are willing, you will get it.
They have
And
to apply, my lord.
they have fairly also, they have suggested that you go for MMCC. There is any requirement of medical or something like that.
Yes,
So how long you will take to fulfill all those things?
give us 4 weeks, my lord, at least.
4 weeks. The substituted
my lord, this order-
substituted respondent is present.
Yes, my lord.
Yes.
Otherwise, my lord, this order was beneficial for us, my lord, because we have to give MMCC for limited time. Till that,
You have to pay.
if we follow this order, my lord, it would have been a limited order for us, my lord. But that is not the scope of it.
What the honorable single judge directed.
Kindly come to my page 76, my lord, the impute. The second part has to go, my lord, thereafter they will apply, my lord, and we will consider. Page 76, para 16, my lord.
Paragraph.
Paragraph 16. First part we accept, second part. my lord.
Also, even charge sheet was not submitted.
Hello?
Even charge sheet was not served. The charge memo was not.
No.
Was done in a very cryptic manner.
All those dues are now paid.
Back
It
with
that
this.
accepted.
So now MMCC, the learned advocate, MS
Only one thing, but the consent word that has been written, no matter, that may cause the trouble for me. That consent word you also recorded. Once, my lord, I was faced with a problem, my lord. I was so caused, my lord, for giving consent, my lord. Because, my lord, the authority, my lord, has not said, but I have just placed the law, my lord, before your lordship, that he is entitled to MMCC, my lord. It will be direction of the court, my lord, to me, my lord. But the consent word, my lord, may cause difficult for
You
me.
have to change the entire order. It's not just one word how it can be moved. The tenor of the entire order is because you had pointed out on the last day.
But I have pointed out that is the law, my lord. That is the
Yeah.
law, my lord. But now, my lord, by stating a law, my lord, in other court, my lord, I was so caused, my lord, in one of my lord.
Say so when we were dictating the order.
But that speak my mind, my lord. Thereafter, my lord. My lord, I thought, my lord, I will be in difficulty, my lord. That's why, my lord. If you lordship consider that, my lord. My lord. That's why, my lord. Because, my lord, they will say that how you are giving consent to the authority, but we have not given consent. My lord. It's like that's why, my lord. You lordship
Last
knows the
statement,
authority.
my
That is the
lordship
law, my lord. I have
suggested.
stated the law. That is the law. I have stated the law, my lord. But in one matter, my lord, I have bitter experience, my lord. That's why I am just saying that. Otherwise, what I could have not opened my mouth before you, my lord. I tried to assist the.
Regarding MMCC, we have recorded a written instruction of the highest person in the management that they are willing to pay in at least 10 cases.
Yes, I know, my lord. There is a circular also, my lord. Wherever they will ask for MMCC, they have to give, my lord.
No. In the disputed matters pending before this court, they have come forward to say that yes, we are paying but without interest.
Yes, sir, my lord. But I
What is the big deal?
will let it be there. But if I face any difficulty, my lord, I will come before you, lordship, my
We will see.
lord. Just I am just indicating that.
We have recorded written instructions. Email has been produced after we adjourned the matter that we are willing to pay but without interest. We have done so.
There is also a circular to that effect also. Now,
So then why are you worried?
in one matter, my lord, the petitioner was entitled to MMCC. I just placed that, my lord. And my lord, I was been so caused, my lord. That how you were saying, if the court gives, you if the court can give. Why you were saying that the issue is entitled to emergency? I have faced that, my lord. That's why I am saying, my lord. Otherwise, I would have not said, my lord. Let it be there, my lord. If I face difficulty, I will come back.
Very well.
I cannot. Sorry, my lord, for the embarrassment.
Item number 8.
My lord,
For the response.
I am led by Mr. Senior Advocate Devojyoti Basu, my lord. He's appearing virtually, lordship.
Change.
But may it please the lordship.
Please ask him to. Where is your counterpart? Please ask your counterpart to come. Please
Very
ask
good.
her to wait. We ask her to wait. We will pass the order at 2 p.m. Please ask her to wait. Yes.
My lord, I appear for the appellate, my lord. May it please the lordship.
বার কর বিশ্বনাথের কাগজটা বার কর বুঝতে পার আর আমাদের যে সাধারণ
Yes, what is it?
My lord, this is a matter, my lord, where, my lord, the order of dismissal is under challenge.
Hmm.
My lord, the subject matter, my lord, that there has been, my lord, two proceeding, one disciplinary, one, my lord, criminal proceeding, CBI. My lord, both on identical charges. My lord, the difference that your lordship would be pleased to see, my lord, subject to my lord's kind wisdom, that only one pillion rider, my lord, which, my lord, who deposed in the disciplinary proceeding and who deposed that I didn't see anything. And the allegation was that, my lord, that after, my lord, completing, my lord, my uh, mm, duty, my lord, when I was returning back, my lord, I was intercepted by, my lord, the CBI police authorities, where, my lord, there was, my lord, an allegation was made by some, my lord, ex, who said, my lord, that in order to give job or contract, my lord, or some tender work in the Kolkata Port Trust, my lord, I had asked for, my lord, bribes and I had taken that. Now, my lord, in criminal proceeding, after, my lord, the trial, my lord, I got acquitted. Now, on similar identical facts, my lord, my lords have already, my lord, gone through, my lord, several judgments, and even, my lord, on a very recently, my lord, off late,
That pillion rider was examined in the criminal trial.
my lord, that pillion rider was not called for. That one witness was additionally, my lord, called for in the departmental proceeding, who, my lord, said, my
So it
lord,
is not a case that the charges are same and the evidence and documents are one and the same.
no, my lord, is almost same. That is what I said, my
Almost
lord.
is different from same.
My lord, correctly,
Yes.
correct. Please, my lord, please. Now, my lord, the charges are same. My lord, I stand, my lord, may I just,
Obviously, that we have understood.
my lord,
Perhaps there will be no dispute on this aspect.
not sure. The charges are absolutely same, my lord. These are identical, verbatim. My lord, only, and the witness, my lord, the list of witness, my lord, those are also same, except one. Except one, that is the pillion rider.
So what is your point?
My lord, my point is this, my lord, that my lord, so
The
far
charge
as
memo, the charge memo, what does it allege? That while returning from work, you were apprehended when?
my lord, apprehending, my lord, when, my lord, at the dock, my lord, charge memo, my lord, proceeded entirely on the basis, my lord, that similarly that the CBI had, my lord, charge sheeted me. Nothing more, and exactly on the same point, my lord. While, my lord,
So
after, my
the
lord,
criminal prosecution precedes the inquiry.
lordship.
So prior to the criminal prosecution, there was an FIR lodged by some individual saying that you have demanded money for employment.
My lord, subsequently, my lord, it became apparent
No,
that,
no, not subsequently. We are asking prior to. What is the allegation in the FIR? We want to know.
my lord, the allegation in the FIR, my lord, is that, my lord, one person, my lord, went to the CBI and he said that, and my lord, my lord, I had asked for
So that
bribe.
is what we were saying, that perhaps
Exactly,
it will be a case where someone has gone to the CBI to say you have demanded money for giving a employment.
exactly, exactly.
Now, when they apprehended you, it was based on such allegation, or there is an alleged recovery of money or something
And
also which is.
my lord, may I also add this? The independent witnesses,
No,
my
no, you
lord,
may not add. First, we tell us the allegation. When you were apprehended, it was
my
just
lord,
based on the FIR, or you were allegedly apprehended while accepting some cash or something like that.
my lord,
What is
sorry,
the
my lord,
allegation?
my lord, I could not hear, my lord.
Ask him to come. Ask him to come. He cannot hear your lordships.
Virtual now.
My lord, I would
What is
definitely.
the charge? He was when he was
FIR
arrested.
page 46.
My lord,
Page
Tell us, please
PC
tell
Act,
us, please tell
Public
us.
servant, he was taking gratification and other illegal remuneration.
So at that,
And
he
Miller
was
did
apprehended.
the
Some
chemical
cash was
test
also,
yes, chemical
cash
test
was also,
there. Chemical test was there.
red-handed.
A chemical test was there and washed away. Now, Millard, the question is, he there, Millard, kindly looks into the Millard, the order under appeal. The order under appeal, Millard.
Millard, I would show Millard everything from the record, Millard. Late Mr. Kollol Bose, Millard.
No,
I would show-
sir, when we ask you what is the allegation, you proceed to the submission. So we have to know the allegation from someone. Therefore, we asked him. We are repeatedly asking you, what is the allegation that you are apprehended with some cash or just based on FIR? You are saying that the other things. So we asked him.
Millard,
Let us know what is the charge against you.
Millard, possibly, Millard, my submissions, Millard, could not, Millard, it is Millard, my shortcoming that could not reach to your lordship. I, at the very beginning, said that there was an allegation that I caught red-handed, and at the
No,
time,
you did
Millard,
not say caught red-handed. You said
No,
there was
Millard,
allegation that you asked money for an employment.
no,
So we
Millard, I
wanted to
said
know whether you, when you were apprehended, there was some cash recovery alleged also, or
exactly,
just
Millard,
based on an FIR.
No, Millard, I stand corrected. Millard, I said that I was intercepted. Well, exactly the correct word that I said I was intercepted
Correct.
when I was at the dock.
Yes.
And Millard, possibly Millard, intercepted at the point, Millard, when I was going with a pillion rider. And Millard, there was I got caught red-handed according to the CBI's FIR.
Very well.
And Millard, there was certain Millard allegation that some caches, Millard, were recovered.
All right. So that is a charge.
My lord.
And the pillion appeared in the departmental proceeding to support that he saw the receipt of money, or he said he did not see.
He did not see anything. He said that nothing had happened.
Apart from him, anybody has appeared in the inquiry?
Millard, all the persons, similar CBI officials, everybody, Millard, and the independent witness, and none of them said, Millard, that there was any such incident, and particularly the independent witness. And in the CBI record also, the criminal trial also, Millard, the same thing happened.
Let's see the inquiry report.
Now, Millard, but since Millard, I appear virtually. But would your lordship, Millard, keep it immediate after vacation, Millard, so that Millard, I do not know whether, Millard, if I conclude my submission, whether Mr. Bose also would, Millard, Kollol Bose would respond to or not. Since, Millard, there are only 2-3 days left. So, Millard, immediate after vacation, Millard, on the very reopening day or immediate one day thereafter, I only, Millard, make, Millard, this much of submissions.
Yes.
Yes, he is, my senior is in difficulty.
1 week after. Any day.
Because otherwise, unless the vacation is approaching,
Paper book is
That's
filed.
why we are also.
paper book is filed, lower court record has been called for. Particularly, I must indicate
Lower
that
court
there was a
record?
coordinate bench.
We are only saying that 1 week after vacation, not immediately on the day of the opening.
No, I am not saying that. I have followed that, Mr. Kollol Bose.
Cannot be 1
I
week
say
after. We have
2
fixed.
weeks.
It will come
2
in the
weeks.
last week of June.
Last week of June.
Yes. Because in the week of 8th, 15th, 22nd, we have adjourned many cases.
Then, kindly,
And
give
after
us
the
a
holidays, we may be having only 50 cases on list.
Monsoon will commence and we will be flooded by your argument.
Mr. Kollol Bose, he will always lead. Then kindly, give us a fixed date and time, subject to my lord's
I
diary.
don't think I have ever passed an order without a date till now.
Lordship.
Ever.
No, Lordship always do that.
Yes.
Lordship always do.
Has prayed for final consideration. Is 19th all right with you?
19th of June, Millard?
Yes, obviously.
Yes, Millard, absolutely.
19th.
19th of June.
Parties, spread by the parties.
At his instance, the matter stood adjourned. Otherwise, my lord,
As paid by learned advocate for the appellant for final consideration of the appeal. It's appeal.
Yes, my lord, it's
The matter is at
my lord, Lordship have kept the matter on 19th. My lord, but any time Lordship would give, or it would come?
all the time.
Lordship, all the times. All the times. As prayed for and my lord, as consented by Mr. Caldwell Bush. Sometimes, my lord, he also prayed for some accommodation.
many a times, because I feared this formidable opposition.
My lord, grateful, my lord, deeply obliged. 19th.
Number 9.
The father of the learned advocate for the petitioner has expired just before yesterday. Kindly just make it not this week. Lord.
We are informed number 10.
That matter where the learned advocate wanted to be changed, that matter, my lord.
Yes, but they did not change. Yesterday they called me and instructed me we will do the matter. And my lord, Pompa and her mother-in-law seriously ill, my lord. So my lord, she irregular in the court. So I'm praying for after vacation, my lord. I can tell.
We are informed. Fix it at 2 p.m. Hardly anything. देखो किस दिन 2 p.m. लग सकता है
19th, if possible, my lord, your lordship.
10 June.
Grateful, my
Grateful, my lord. जिला परिषद is
I'm grateful.
Number 11.
For the respondent.
You are for which respondent?
For the mother dairy, my lord.
The learned advocates. There is no.
Uh,
12.
12, my lord, I am for the response.
Time for the appellant.
Can application.
Yes, my
How
lord.
many days?
Delay, my lord, in our application, 28 days. We have
28.
calculated 28 days.
Not the case. Evening quarter. Petitioner, two read
Two read
petitioner is there.
petitioner. Two read petitioners.
36 days and 2 petitions. One petition.
One petitioner.
Number 13. Yes, there is one petition. In item 13.
30.
Oh.
13 দিলেন দাদা, এটা কত দিল? 13 দিল?
It is 40 days.
40 days.
Fourteen, 14,
14 and 14.
14, my lord, I am.
I am led by Mr. Somrat Ghosh. My lord, I am praying for not today. My lord, he is ill. That's why he doesn't come in the court.
Lord, up to 18, then my lord.
Same.
All these
Yes,
three.
my lord.
Which matters? Serial numbers?
18 up
15,
to
16, 17, 18.
14 to 18.
14 to 18, my lord.
Not today. All these matters not today.
18.
Number 19.
19. Is it 19? 19.
19. One minute. Yes, sir.
May it please your lordship, I am applicant in person. I am very much obliged for allowing me to appear on a convenient day.
Sir, this appeal is fully confined to a very narrow issue. That the learned judge in the paragraph 46,
26.
46, 46, 46
Yes.
has held that the application of a shield cover in 2015 was illegal and has granted me the notional promotion to AGM with effect from 1st June 2016, 15. The day my immediate junior has got the promotion to the AGM post. Sir, I am not challenging this finding. However, in the I am in that finding in the paragraph 47 that the petitioner did not press for any further promotion and therefore such relief cannot be granted is factually incorrect. That is, my lords, the finding contrary to the record.
Then you are required to file review. Why you are in appeal?
Review it is the domain of the promotion.
If there is an error of record in the order, then you
No,
don't
it is
file
not
appeal.
a-
You are required to file review before the same court.
My lord, it is not any error mistake. It is only I am denial of the promotion.
You are saying paragraph 47 is an error of record. So error of record is required to be raised before the same court by filing a review, not appeal. We don't know. We cannot put ourselves in the shoes of the Honorable Single Judge to know whether you press for any further promotion or not. She is the only one who can deal with this issue.
But it is narrated in the paragraph 17. It is there. It is paragraph. It has been recorded that I made the prayer for a national promotion to the DGM with effect from 1st March 2018 and general manager from the 1st April 2021. It is there, my lord. Everything, even my written submission has expressly pressed for that consequential promotion. But it is in spite of everything in that record, there is a denial of the consistent promotion. That's why I am challenging. It is not that it is everything is there in the record. Still means and everything in the paragraph 41 to 43. The learned signature has held that the petitioner promotion stood withheld. It is means that he thereby lost the opportunity to the consider further promotion, and that no order of withholding promotion was passed. That denial of a future promotion was impermissible. Everything is there. Even, my lord, in the Union of India, KB Rajoria, it was discussed that the notional promotion is intended to do the right to the wrong. It is there in the 36 of the paragraph. The failure to extend the further promotion would perpetuate the illegality. It was discussed. Everything was discussed. My lord, governing principle in the service jurisprudence is the restoring must be complete, not partial. My lord, I will cite also some case laws. Ajit Singh and the state of Punjab and Food Corporation of India and Parashuttam Das Bansal, Union of India and Hebraj Chauhan, where everything there is right to equality and the consideration of the promotion in the fundamental right to 16(1) is given properly, fairly. If you permit me, I can hand off the case laws of Union of
of India and KB Rajuria and Adit Singh and others and State of Punjab, Food Corporation of India and Union of India, the fundamental rights. And in case of a perpetual of illegality, means what?
Yes, where is your writ petition? Where is your writ petition?
Writ petition. My,
In the writ petition, did you make any prayer for the subsequent promotion?
writ, yes,
Where is it? Show us. You are still in service.
no, I am retired,
When?
in 2024,
21.
24,
Which date?
29 February 2024. Actually, my lord, this case is lingering from 2016 onwards. I made 18 representation to the respondents that shield cover is not applicable in this case, but they replied with negatively. They did not had any of my prayers to them. Last line. At the filing stage, only the junior was promoted up to DGM. So prayer is contained with that only. That last line of the 46 page.
DGM is in which scale?
Scale 5.
You have already been promoted in scale 5.
No, they put it that after the promotion in the May 2015 means the effect of the promotion was my junior, immediate junior got the effect of the promotion from 1st June 2015. And it was not updated in the internal system, in the computer system, it was not updated. I wrote 18 letters to get it updated.
There is a direction to promote you in scale 5.
Yeah.
The post of
I was promoted in 2015, my lord, but that was in 2017, 4th October 2017. They wrote a letter to me in response to my representations that your case is in the sealed cover procedure, and they did not allow me to appear for the DGM post. They did not invite me. They never considered me in the zone of consideration. My right has been curtailed there.
just now you said that DGM is in scale 5.
Next, DGM is scale 6. AGM is.
We ask you, you say scale
I
5.
could not properly hear, my lord.
So now you are seeking a scale 6. After a promotion in scale 5, what is the procedure for promotion to scale 6?
It is there, my lord. Only APAR is required only. APAR, annual performance appraisal report.
Annual performance appraisal.
Report.
There is no departmental exam or anything.
Exam is not required in that case. Only interview. Only the process of interview. Actually, they did
interview.
Not,
so there is an assessment.
Yeah.
There is a process of assessment. So
that should be APAR. Means performance should be means meritorious. Yeah, my lord. Yes, my lord. Please ask me.
After a promotion to scale 5, what is the period which is required to be spent in the scale 5 for becoming eligible to scale 6?
3 years.
3 years.
3 years. But my junior immediately got the promotion within the 2 years period. So I will get. I have that my it sets the record in that way. Means that relaxations has been allowed. My junior
Relaxation or anything can be allowed provided you participate in the promotion policy. A promotion procedure. If you have not participated in the promotion procedure, how you can get it?
I am not.
Without interview, how you can get it?
My lord, when they have put me illegally, they have put me in the shield cover. They have not allowed me. They did not consider me in the zone of consideration. How I can so much go and appear before them? It is the illegality they have committed. That is the erroneous decisions they have taken in that.
And what is the effect of this punishment? Punishment was imposed in January. January 2016.
2016, that punishment, what is the effect of that punishment?
Only minor, that is not withholding of the promotion. It is clearly mentioned in the judgment, my lord, in the 46.
We have seen that. We are not asking you what is the punishment. We are asking you what is the effect of punishment. In every service rule, there is a provision which says the effect of such and such punishment shall be.
One increment for the 6 months, it was reduced, then it has been reverted.
Where is your service rule? You are probably, we are not clear to you. Where is your service rule?
Service rule is the promotion policy.
Where is it? No, not promotion, sir. Please try to understand. A very simple punishment like censure.
It is,
Just please listen to us. Even if a censure is awarded, there are service rules which say for 3 years he will not be considered for promotion.
no, my lord. It
So what
not-
is the consequence of the promotion we are asking you? We are not asking you what is the promotion.
Actually, there is no, in the minor punishment, withholding of the promotion is not there. In the, my lord, it is only about.
There is the consequence of promotion in which provision under the service rule show us. Please respond to what we are saying. Don't repeatedly say the same thing. We have understood what you are saying. You are not understanding what we are saying. We are asking you where is the service rule? Does it have any stipulation that every punishment shall carry a consequence of any kind? Where is the service rule?
My lord, if means that is if before the date of a promotion, if the currency of a penalty is there, means that would be extended for the further period that is there. But if after the
After the currency of the punishment is over, there is no
such-
consequence.
There is no such in the mind.
Where is that provision? Please show us. It
In the-
must be
in the-
stated in the service.
314, my promotion policy.
See it, where it is. That's not the point. The point is every punishment has a conflict with the punishment. In WBS also. Three point 13.
313. Sorry, 314. Sorry, 314.
This is not the relevant provision. This is the promotion policy. This is only dealing with
My-
if
just
a
the thing
punishment
that
of
was-
withholding of promotion is passed, then only that is prescribed.
My lord, please think, if suppose I would not be illegally put into the shield cover, I would be considered.
You are saying this for the 5th time. You need not say it 5 times. We heard you the first time. What we are asking you is, where is the service rule which contemplates the punishment? Please try to understand what we are saying. Every service rule prescribes the punishment, penalty, and effect of penalty. So what is the effect of penalty? We want to see that for this withholding of, what is it? Withholding of 1 increment
One increment
for 1 year only.
No, my lord. It is not. It is not there. There is no deferment at all in minor punishment.
In your case, what is the punishment?
Only that is the minor punishment. One increment 6 months non-cumulative basis.
Non-cumulative for 6 months. So what is the effect of such punishment? That will be specified in the service rules which prescribes the penalty. It will not be contained in the promotion policy. Where is the service rule? Your bank service rule.
Actually, in the 2000 policy, promotion policy, it was there for the 2 years. If 2 years, that is not included here. Actually, wrongly they have given that advocate has included this 2017 policy. Actually, in the 2015, 2 years time for the deferment of the any further consideration. If a punishment is given for
Any punishment. For any punishment.
minor punishment. For
Minor punishment, there is a deferment by 2 years.
That is minor punishment of up to 2 years and above, sir. I am telling. That is, sir. Exactly, I have forgotten that.
You
that is
don't
there.
tell us from recall of memory. Show us the service rule.
That is there or not? Actually, one file is there. I don't know exactly. I have forgotten that one.
You will have to come with the rule. Otherwise, how we can consider? You will have to come.
Only one thing that illegality that I am telling. And
You keep repeating that for as long as you are standing. Then we will consider that only and will dispose of the matter. And then you will say that the court did not consider, like you are saying right now, that the single judge did not consider. That's a problem when you appear in person. You don't. That's why it is better to come through a lawyer. You are so passionately attached to your cause that you are unwilling to understand what the court is trying to ask you. You think that every query is hostile to your case. All the queries are not hostile to your case. We want to understand what is the situation. There is a provision in every service rule regarding an effect of punishment. Where is that provision? We are asking you for the last 10 minutes. You are running in circles that it is their fault, therefore I have been deprived. It is their fault, there I have been deprived. We have understood that.
One circular last time it was given in the.
No, you bring the service rule under which the punishment was awarded.
UPT circular 20.
Whatever it is, this is a bank. You are in the bank service.
I was, yes.
Then it must be having a conduct rules. It must be having a disciplinary conduct rules. Where is that rule? What is the effect of a punishment? Yeah, I think even in WBSR there must be a provision that if any punishment is awarded, then you will not be considered for any further promotion for so many years. So many service rules, there is such a provision. We want to see whether there is any such provision. If there is no provision, then the consideration will differ. If there is some provision, then whether after that period by which it is deferred, maybe you will entitle, we don't know, but we want to see the rules.
May I be given another date?
Yes, you serve a copy on the bank also.
Okay, I'll search. I'll come
The
again.
petitioner appear, the appellant
And 20. Lordship, my senior is appearing in this matter. State is the answering respondent. He humbly prays to keep the matter after vacation. And 21.
I am for the petitioner, my lord. My lord, there is a direction to file, my lord, affidavit in opposition to our supplementary affidavit. That is. Any কবে আসবে? 30/6
And 22.
My lord, 22, I'm for the petitioner, my lord. My lord, also, my lord, state is the party, my lord. My lord,
You will not appear.
my lord, I tender my apology, my lord. For that reason, I shouldn't have anticipated, my
We are
lord.
going to dismiss it
No,
yesterday.
my lord, I tender my apology, my lord. This is our fault. My lord, affidavits we have exchanged, my lord, but since the state is
So opposition and
opposition, they have supplied copy. We have also affirmed affidavit and supplied the copy to the state.
both are yet to be filed.
Yes, but not yet filed.
How much yes for the state?
Well, Mr. Baxby is appearing on.
Yes, both of you were absent yesterday. Both of you were absent. Both of you were absent yesterday. We were going to dismiss it in default.
Eighth also as well, my lord.
So we sent an invitation.
We could not anticipate that is our only one fault that we have committed. Both of us will not have anticipated the court's mind, Millard, without there being any ground reality. We thought, Millard, the counsel who normally appears for the state will be absent from the court, and that was our, Millard, absolutely misunderstanding of the situation. Kindly excuse us, Millard.
Yes, sir.
And 23. Item 23. I appear for the petitioner. Well, they have filed their affidavit. My affidavit is also ready. Well, matter relates to suspension and prolonged suspension, my lord.
How long?
Lord, from 2019, I was involved in a criminal case. I got acquittal from the criminal case. My lord, still the suspension is continuing. Now, the suspension order says because of your involvement in English Bazaar PS case number such and such, for more than 48 hours detention, for more than 48 hours, I have been suspended. Now, Lord, in that case, my lord, FRT has been filed and is accepted by the Honorable Court, but learned court. Well, page 45. But at least copy has been served upon us. Well, I do not know it's filed with the and my lord, the reply is also ready with me, my lord. And I will say, project file আছে কিনা কে জানে? But can it be earlier part of the holiday?
In the first week.
First is correct.
No, first week after you.
After vacation. 24.
I am for the petitioner. Last occasion, your lordship heard the matter and my lord directed me to bring the PPO because my lord, I returned from the year 2026. It was reflected in 96. It was reflected in my service book. But my lord, they have issued my lord the PPO. Where from it appeared, my lord, they calculated my pensionary benefit from the 1997, my lord. So, my lord, your lordship directed me to bring the PPO, where from it reflected the date of return, date of joining, 1997, first May 1997. This is the PPO, kindly see, my lord. And my lord, kindly come to my service book, my lord, running page 36, my lord. Yes.
This is PPO.
Yes, my lord. part two, my lord, kindly consider, my lord, part two, where from you appear on the date of appointment, 1st May 1997, my lord. So, my lord, I pray for your
So
lordship.
did you approach the authority for rectifying this error?
But they have calculated not I that leave may be granted, my lord, to direct them to consider, my lord, that, my lord. Otherwise, they will not, or my lord, leave may be filed by supplementary affidavit annexing this, my lord, and my lord, state respondent may appear.
Unless you avail the remedy before them, how you can approach the tribunal?
Tribunal is non-functioning, my lord.
Sir, you filed the OA.
Yes, my lord.
When you filed an OA, you are required to comply with section 19 and 20 of the Administrative Tribunals Act. So unless you have exhausted your remedy, how you could have approached the tribunal, that we are asking you.
My service book is reflected, my lord. My appointment is, my lord. Kindly see, my lord, the service book, my lord.
Again, we are asking you.
Sorry.
If you have approached the tribunal, you are required to comply with section 19 and 20 regarding exhaustion of remedies and limitation. If you have not approached the authorities, how you could have approached the tribunal? Was your application maintainable?
That leave be granted, my lord, to approach the same.
The learned advocate for the application. We make it clear that we have not expressed any.
25, I appear for the petitioner, my lord. Although the university is appearing today, the main answering respondent here is the state respondent, my lord.
After holidays, none appears for the state.
Till 26.
10/27, I am appearing on behalf of the petitioner. I mean, answering respondents is the state, my lord. Lordship had granted us liberty to file a supplementary affidavit, and we have done that. Copies has also been served.
After holidays, both matters.
Yes, sir. 128.
For the petitioner, my lord,
Same.
file our affidavit in reply.
How can you unless opposition is filed?
No, they have filed their opposition.
They have already filed it or only served you. They have served on you but not filed. Let them file after the holiday, please.
Twenty-nine for the petitioner. Last occasion, your lordship directed the state respondent to take instruction regarding the similar benefit, my lord. But till date, they have not filed any report, my lord.
After the holidays.
30.
The petitioner, my lord, same prayer.
Same order.
And 31.
51, there was direction to file affidavit by the state.
State. After holidays.
And
Afterwards.
And 32.
Well, I have this.
After holidays.
The only thing your lordship on the last occasion had directed the respondents to, this is with regard to suspension allowance. I have not been paid for the last 6 years. The last
Subsistence allowance.
suspension, subsistence allowance. On the last occasion, your lordship had
For the last 6 years.
6
Your
years.
proceeding is still continuing.
Disciplinary proceeding was initiated immediately after my application before the
Is
state
the
tri-
proceeding still continuing?
Yes, it was initiated after my application was dismissed before the learned state tribunal. Your lordship, on the last occasion,
Then how you were getting a subsistence
I
allowance?
am not getting it. I got only for 3 months initially. I was suspended in October 2019. I had got for October, November, and December. Since January 2020, I am not getting anything.
Then why you filed an OA in 25?
Well, I had been given representations before the authority. They each and on every occasion I was asked to submit that non-engagement certificate. Everything was complied on from my side, but still they refused. I approached this learned tribunal. The tribunal, while disposing of my application, held there was no review of my suspension. Nothing was done. On the last occasion, when your lordship had admitted the matter, the lordship had directed that to see that my suspension allowance is paid. In spite of the direction, the authorities are now asking for documents. They are holding inquiry. They are conducting hearings before them.
Why have you filed the writ petition when the relief was allowed by the tribunal?
No, the tribunal held everything, save and except that it did not allow my suspension application, my prayer for suspension allowance. That was not allowed. Lordship would kindly come to the order of the learned tribunal.
Where is your OA
OA, I have annexed,
page?
just the OA is at 55. It starts from page 55.
And where is your prayer for such a benefit?
The benefit,
Where is your representation made? Prior to approaching the tribunal, when did you make the representation?
well, it was last made on 21st of May.
Which page, sir?
Well, just just before, at page 50. Well, these are all the representations that was made before the authority.
You are been paid subsistence allowance.
I was paid for 3 months.
Where is that averment in your OA that after 3 months subsistence allowance was not paid?
Page 1 of my OA, page 57. Thereafter, page 4, page 60. Running page 60.
Yes, you read 4.7.
That on and from January 2020 and onwards, the applicant was neither paid suspension allowance at the enhanced rate of 75% of his basic salary and other consequential benefits.
So you are being paid subsistence allowance.
Neither paid. I have not received anything.
That's a wrong submission.
But
You are claiming subsistence allowance at the enhanced rate of 75% instead of 50.
Initially, what my service rules.
See, your submission is expected to be founded on the records.
Yes.
The records are clear that you got 50% pension for 3 months. Thereafter, you are seeking enhancement of 275%. It is not your case that you are not being paid subsistence allowance.
In fact, the order of the learned tribunal.
Forget about the order. When you make a submission, we expect that you will make a submission founded on the records. You think you can pull a fast one by making such submission?
Absolutely no. And
you cannot. At least before this bench, you cannot.
Absolutely, that is not at all my intention. That is not.
You said that you are not being paid subsistence since 2019.
No.
And therefore, we were surprised.
No. Since
your case is you want an enhancement and review under the rules. So instead of 50, it should have become 75, maybe 100, provisional, full, whatever. It's not a case that you are not being paid subsistence. Then don't make such submission, incorrect submission.
Let's see.
Don't make such incorrect submission and don't try to justify making an incorrect submission. Contrary to the record. Immediately we found out, we told you, still you are insisting that see such and such paragraph. That's not your case. Very unfortunate. And the review has been directed by the tribunal. So what remains? The tribunal has directed for review, so there what remains? Why did you file the writ petition? We don't know. Most unwanted litigation. Litigation for the sake of litigation. See what the tribunal has directed. Come to the last paragraph. Directed the collector to review the payment of subsistence allowance. That is exactly what you went to the tribunal for. Why are you here?
What I meant to say before the learned tribunal was that so far as my subsistence allowance is concerned, since 2019 when I was suspended, I was initially paid for 3 months. I was paid at 50% of my salary that was there. Now, according to my service rules, it was said
that we already discovered from the records.
Yes.
You said you are not being paid. We discovered what your case is, and that has been directed by the tribunal. So we are asking you, why are you before this court?
if I may draw your lordship's kind attention to page 57, second
Yes.
paragraph.
Yes.
What your lordship is
Any representation you show which says you are not being paid subsistence allowance. Any averment that you are not being paid subsistence allowance. That's not your case, sir. That is what was argued before the tribunal. That is what was directed by the tribunal. Read 4.7 again and again. It says 50% for 3 months, thereafter enhanced is not being paid. Nowhere it says that I am not being paid any subsistence allowance. That's not your case. That is why relief is also that direct them to pay 75%. Your relief is not to pay the subsistence allowance. You come to your relief 6.1. What is this, sir? Why did you file the writ petition? And the tribunal has already directed the collector to review. Why are you here? This review is under Rule 71. What does it provide? After 3 months, it should become 75%.
3 months, a review should be held. Now,
Review has to be held.
There has
Whether
been,
the continuation is desirable or not.
there has been no review till date also.
So that review has been directed. Why are you here? We are asking you again and again. Which provision it is? What is the rule? If you remember correctly, it is Rule 71.
71, yes.
WBSR.
Yes, it is 71. What is to be done? You tell us why the writ should be kept pending.
May I request your lordship in that case to kindly direct the authorities to expedite the review so that, because
And 33.
great.
My lord.
My lord, I am appearing for the applicant. Item number 33, I am appearing for the applicant. My lord, on the last occasion, directions were issued for filing of affidavit. If your lordship kindly take up order dated 23rd of March 2026.
After holidays.
My lord, can it be, my lord, after 1 week of the holiday? Because, my lord, there is some certain urgency
What is it?
in
Tell us,
this
please.
matter. My lord, the urgency is relating to applicant has participated in the post for homeopathic medical officer. He has filed his online
1 week after,
application.
1 week after the holiday.
Deeply obliged, my lord.
Is any interim order requiring to be extended?
No, my lord, no. No interim order was passed, my lord.
Yes.
Deeply obliged.
Item 34. Well, item 34, my lord, I received instruction from my client, my lord, although my WhatsApp message, my lord, that he doesn't want to proceed with this matter, my lord. My lord, it's not the original signature is there, but this WhatsApp message, my lord, kindly allow.
He has come to the High Court for what?
My lord, against a petition for filing of contempt petition, my lord, where the order
Tag it.
not been complied with, my lord, আরেকটা copy দিয়ে দিন, he's going to read.
Oh, he has approached the High Court for compliance with an earlier order passed by the tribunal.
Absolutely.
Now he says it is already complied.
More or less, he's complied, my lord. He's going to return on 30th of September, my lord, so he doesn't want to proceed, my lord.
One communication.
Mr. 35.
I am appearing for the petitioner led by Mr. Johnson Chatterjee. This matter was lastly taken up for hearing on 6th of May when your lordship was kind enough to direct them for filing of the opposition. But yesterday I was in receipt of this communication. This was addressed to me by the law officer that they have no objection with regard to payment of the GPF and, my lord, the provisional pension with regard to the claim of the petitioner. This is the communication which I received yesterday.
So what do you want?
Well, the opposition they have not filed. That is.
So what do you want? Does that satisfy you?
My lord, no. This.
Then let them be here.
My lord.
Just after the holiday.
36.
At 36, I appear online. This is I appear for the petition. This is the answering respondent where an application is pending before the tribunal, and the tribunal has fixed the matter on 22nd of December 2026. Last week.
Just after the holidays, what can be done? Yes.
May I get a date immediately after the holidays? 8th or 9th?
No, sir. We'll give it in the third week after the holidays. More urgent matters we are accommodating in the first week or second week. We'll have to
Very
prioritize
good,
what
very
can
good.
be done. Yes.
Very good, very good. Grateful. Well, may I leave?
Yes, please.
Grateful.
that consent part, my lord.
Just a minute, yes.
Your lordship asked us to come at 2, my lord, to that consent part, my lord.
We will slightly modify it. Instead of consent, we'll say is not in a position to oppose this.
Keep your-
No, it will, मतलब she will get the area monetary compensation from the date of his death. Of his-
Obviously, that is the scheme, yes.
Just in matter act number 1.
Lordship, I am appearing on behalf of the appellant. Lordship, if the matter,
You are required to file an affidavit.
yes, Lordship. Lordship, if the matter may be kept after the vacation, Lordship. Meanwhile, I will file my affidavit, Lordship.
No, there are too many adjournments in this matter. We have found yesterday there are
Yes, Lordship. Lordship, state is also not appearing, Lordship. If
forget about state, you are required to file an affidavit. Why you have
Lordship,
not done what you are
we will
required?
file, Lordship. In the meantime, we will file our affidavit, Lordship.
File it this side of the holiday.
Okay, Lordship.
February 20. This is pending since 21, this filing of affidavit.
No, Lordship. Lordship, this affidavit is pending since last 2 occasions.
No, it is pending since 9 February 21.
Lordship, thereafter the matter was heard in part also, Lordship.
You look through the order of 9 February 21.
Yes, Lordship, but Lordship on October 31st order, 31st October 2025.
Which
order dated 31st October 2025. Lordship, the matter was heard. I apologize, Lordship. Lordship, order dated 19th November 2024. Matter was heard.
So therefore,
Lordship, thereafter the matter was listed recently, and thereafter there was a direction for affidavit. Lordship, if this last time
you
time may
read
be
the
allowed.
order of 31/3/26.
Lordship, 30.
What is this? You are making such submission. So what? 25 it was heard. That what does that mean?
Lordship,
It is pending since February 21.
Yes, Lordship.
What is this? How many years?
5 years.
So it is just for adjournment purpose. This matter is being listed.
No, Lordship.
For the lawyer's appearance every day. That's all.
No, Lordship.
Then what is this matter?
Lordship, will file our affidavit in.
From February 21, we are in 26.
Lordship, thereafter there is a.
More than 5 years have lapsed. In between, inadvertently, without going into that order, if you have made some submissions, what is the effect of that? What does that mean? Why you are drawing our attention to that order? We don't know.
I apologize, Lordship. Lordship.
The records reveal a shock. From the records,